Hello and welcome to today's webinar, Non-Disclosure Agreements, When You Should Require an NDA, When You Should Sign an NDA. I'm your moderator, Jenny Alton, from the New York Small Business Development Center Central Office. Today's presenter is Dr. Jessica A. Magaldi, Ivan Fox Professor and Scholar of Business Law at Pace University's Lubin School of Business. This webinar is brought to you by the Pace University Small Business Development Center. The Pace SBDC is part of the NYSBDC network of 22 campus-based centers and outreach offices located across New York State, along with a central office based in Albany. The NYSBDC is a U.S. Small Business Administration resource partner. Our free advising, education, and advocacy services are made possible by funding from the SBA, New York State, and our host campuses. So you know, this session is being recorded. We will share it with attendees after the webinar. Attendees are muted and will not be on camera. Your chats will only be visible to myself and our presenter, and Andrew, who will be also assisting with today's webinar. If you have any questions during the presentation, please don't hesitate to type them in the Q&A box as they come up. You can open Zoom's Q&A box from the Q&A button at the bottom of your Zoom window. We will address questions at the end of the presentation. We'll answer as many questions as we have time for today, but for very specific questions that may take more time and detail to answer, or if we run out of time to answer all questions, you can get in touch with today's presenter through the contact information she will share at the end of the presentation, as well as replying to the follow-up email you will receive tomorrow if you would like to get further assistance from the PACE SBDC. And with that, I will turn the time over to Andrew Flam, the director of the PACE SBDC.
Great. Thanks so much, Jenny, and good afternoon, everyone. Thank you so much for joining us today on a terrific session, which will be covering non-disclosure agreements. I'm delighted to have my colleague, Jessica Magaldi, back to lead today's session, and we'll be with Jessica in just a moment. Wanted to just quickly run through a bit of information about kind of who we are and what we do, and hopefully how we can be able to help you as you build and grow your business here in New York State. As my colleague Jenny Alton had mentioned, my name is Andrew Flam. I'm the director of the Small Business Development Center, or SBDC, here at Pace University in Lower Manhattan, and we're one of 22 centers located throughout the state. So for those of you dialing in from New York City, certainly feel free to use us as a point of contact that we can help you, whether it's in operational issues, financial, marketing, and other ways that you kind of build your business. And if you are operating from elsewhere in the state, we're happy to also connect you with our colleagues from other centers throughout the state as well. As Jenny mentioned, kind of our focus is on providing one-on-one business advisory services. SBDC centers are staffed by full-time business advisors who are really sharp and very, very committed to helping entrepreneurs as they're expanding and launching their business. They're very able to kind of connect and work with you in areas such as access to finance, marketing and sales strategies, such as building websites, social media presence, and other email marketing and other opportunities to connect with your clients. Looking at operational issues, how to kind of reinvent and kind of restructure your business, post-pandemic, and of course looking at various pandemic and other grant and loan programs that might be out there that might be a good fit for your business. This, in addition to government procurement and a wide range of other issue areas, are things that the advisors can work with you on, really tailoring their support to things that you need help with. So again, keep us in mind if you're not working with an SBDC already. All of our services are offered at no cost. There's a quick advisory session counseling request form that I will put in the chat in a moment. It just takes a quick few minutes to fill out, and then we can kind of get you set up to meet with an advisor. So do keep us in mind if you're not working with the center already. We'd be happy to work with you and help you. In addition to our one-on-one training programs, our center, as well as our colleagues throughout the state, offer a wide range of training programs like this for you, some virtually, some in person. So certainly we would encourage you to kind of take advantage of those as we kind of bring in expert speakers on a wide range of topics. So as I pointed out, our colleague Jessica Magaldi will be speaking today. And in fact, we're delighted also to have Jessica back next week. And I'll put a link in the chat for that. We have a session on contracts and risk management. If you find today's session helpful, hopefully you can join us for that one as well. Finally, I want to just again, thank you all for taking the time to kind of connect with us today. And as Jenny had mentioned, if you have questions afterwards, you certainly either you can contact us through the chat function, or certainly email us as well, and I'll put our contact info in the chat. So again, thank you for joining us today. And with that, I'd love to introduce our guest speaker today, which is Jessica Magaldi, my colleague here at Pace University. So Jessica, it's all yours. Thanks again for leading the session for us.
Thanks, Andrew. Thanks, Jenny. I'm happy to be here. So I'm presenting on non-disclosure agreements, what you ought to know when you are asked to sign one, or what you ought to know if you want to protect your information and want to ask someone else to sign one. So let's jump right in. What's a non-disclosure agreement? It is, it's a contract document. It's a legally binding document that protects information that one party wants to keep private. So when you have to disclose information to someone else, but you want some legal protections around that. You can also use it to keep the entire transaction. So not just the information, but just the fact that we're talking, the fact that we are contemplating a business relationship. You can keep that. You can use that to keep that private. So the most important thing to think about when you are either faced with an NDA that someone's asking you to sign, or when you're crafting an NDA that you'd like someone else to sign, is, this idea of protection versus burden. The more protection you're going to give to the party who's disclosing information, the bigger the burden you're going to put on the receiving party. So as with everything, you want to find that, that perfect balance. And some of the things that we'll talk about today will, we'll address that balance. We'll give you some framework within which to contemplate these things. So before we go too far, I just want to address the elephant in the room. We've seen non-disclosure agreements used in a variety of somewhat nefarious ways. So when I say we can use to keep confidential the underlying transaction or underlying relationships, sometimes we have seen that, that done. So, NDAs have been abused in situations where there's a power disparity between parties, and they've been used to silence people who might otherwise, come forward. But a few states, New York among them, are making reforms. And New York's particular reform, allows confidentiality clauses only at the request of the party with the lack of bargaining power. So one benefit of the sort of reckoning we've had around Me Too. For a more cheerful way to think about it, what's more cheerful than Lin-Manuel Miranda? He told a really funny story about how when he was composing the music for the movie that he did, one of the most catchy songs in the movie was "We Don't Talk About Bruno." He talked about how his 4-year-old was like humming it and singing it as he went to school, and he had to explain to him, like, these are things that we can't let out yet. Like, it's a work in progress. I'm under contract. I can't, please don't tell anyone, or don't sing this song for anyone. So I love the idea that that we don't talk about talking about Bruno, but that, he's trying to explain, an NDA to a 4-year-old. So, how do you know if you need an NDA? So if you're composing music and your 4-year-old is possibly singing it in his grammar school, then, that's one way to know. But otherwise, you might think, if you've got another party that you're going to reveal confidential information to, information about how your business works, who your clients are, and if they're in a position to interact with your competitors or suppliers or potential business partners, you want to use an NDA with those folks. So you can use an NDA with your employees, with your, we're going to call partners, because a lot of times in the business world, you all refer to people as partners, but they're not legal partnerships, but they're just people with whom you are partnering on a deal, or, engaging with in some collaborative enterprise, also can include your vendors in that. So there's no there's no prohibition on anyone who can sign an NDA except, New York's rules around power disparity. But it's all a matter of like what the relationship is and who's willing to, engage in that with you. So I want to set out, we're going to actually talk more about the relationship and who might be willing to engage and how you might encourage someone, to agree to terms that will protect you. And we're going to talk a lot about that actually as we go on, but I just want to set out some things about some terminology to get us started. So confidential information is however you define it in the document, and we're going to spend a bit of time trying to figure that out. And then we refer to a receiving party and a disclosing party, the party who discloses the information to the other person. But either party can be two people in a transaction, two parties to a transaction can be both a receiving party and a disclosing party if you are sharing information that way. Or you can target an NDA to protecting only one of the parties' information. If you're contemplating buying my business, and so I'm the person who's giving all the information over, we might need a one-sided NDA just to protect me in that situation. So I said either party can be either a receiving or disclosing party in a mutual NDA. And I want to say that I often recommend a mutual NDA, even if only one party is disclosing. Makes people feel comfortable if terms apply to each side, and also allows for flexibility if you've got, you didn't expect that you were going to disclose information. So you thought that the NDA could be one-sided and just benefit your other party. But, something comes up along the way and you do disclose, you don't want to have to now sit down and write another NDA. You're already ready in that situation. So who should consider signing or asking others to sign? Anyone who's entering into a commercial transaction or a relationship, and anyone even contemplating or exploring those kinds of things. And you can also use an NDA after the fact. You've inadvertently disclosed information that you thought was, so you've inadvertently disclosed confidential information, perhaps because you were thinking that you were going to be disclosing things that were, they didn't need to cover with a contractual relationship. But then as the conversations progressed, or one of your employees maybe said something that you didn't want, you can use them in a backwards fashion, in a retroactive fashion, and we'll talk about that. You can use NDAs with employees. If you've got an employment contract, you can put that in you can put that as one of the terms of the employment contract. And since in the US, most of our employees are at will, right, non-contract employees, it's often customary, especially if you're in a technological field, to have some sort of intellectual property agreement or invention assignment agreement where you are we're already in a you're already forming a documentation, a documentary relationship about who owns what or how things are going to work. So you can pop your NDA in there as well. You can also have a standalone agreement. For employees who are separating, if you didn't have something in place during employment, if you didn't have something in one of those documents, or a separate standalone NDA, and then you become concerned upon separation that the employees got lots of information that you would prefer to keep confidential, you can put one of these retroactive documents in place, so you can cover information that they've already learned. In order for that contract to be binding, in many cases, though, you have to offer consideration. You have to offer something to the employee for taking on the burden of maintaining your confidential information. And that's often severance. So if you're already doing severance, when you're putting your documents, your separation documents in front of the employee, you can include that as well. We often see the terms proprietary information or confidential information. And there's a small difference between them. Proprietary information is something that you own, but confidential information is potentially larger than proprietary information. It's anything that you want to keep private. So, the formula for Coke is proprietary information, but how I, how I manage a sales process with all of my salespeople, from inside sales to the folks who are interacting with the client. That process might not be proprietary necessarily, but it might be something that you want to keep confidential, right? It might be comprised of all things that are in the public domain, but the combination of them is what's proprietary to you, is what's confidential to you, and you want to keep private. Some key NDA issues. This is a sort of an outline of what we're going to talk about today. I don't know why the little pictures are coming out like that, but we're going to talk about what information we can protect, what information we can't protect, what information we might not want to protect. And then the point of the NDA really is embodied in number 2, right? It's restricting the scope of the use. Like, how can parties use the information? We want to provide for an option to return or destroy the confidential information at the end of the relationship. And we want to have some limitations on how long the parties keep confidential. And then none of this would matter at all if we didn't have some consequences for what happened if things didn't go the way we wanted them to go. So we're gonna take each one of these in turn, and we'll start here with defining what information is protected. The primary disclosing party is the driver of this conversation, right? What they're seeking to protect, and then the scope of the protection that they can get is dependent on the relative negotiating power. Like, how important is it for them to get the underlying relationship or underlying transaction moving? How much time they have to put these documents together, how motivated they are versus the other person to enter into the transaction. So obviously a broad scope of confidential information will support the disclosing party. The wider you cast the net, the more things that you will protect. So here's a few different ways that you might want to describe information, and then a few concerns around, how we're doing that. So you can think about, you can say all information that's given to the receiving party. You can also say, all information that's accessed by, right? If they're going to be, rooting around in your files, electronic or otherwise. You can choose to say anything that also includes anything that the receiving party creates, that if they base it on your confidential information. You can make it as, the broadest way, all information relating to your business. Of course, you want to be careful to say, no matter what level of information you choose, what level of how broad do you want to be? You want to at least make sure that you include tangible and intangible information in that. Some people, so you can say marked or unmarked. Obviously, marking information as confidential and having only documents marked confidential as being confidential information under the scope of the agreement, that will help the receiving party be very clear about what's their information and where their obligations are. It will be very limiting, or more limiting though, to the disclosing party. So some people talk about marked or unmarked. Some people say you can say marked information or anything related to that marked information. There's some ways to craft this language. And you can also, get that retroactive benefit by saying anything that, prior to the time that we signed this agreement, but anything that was given in one of these categories, right? That was marked, that was tangible or intangible, that was prepared by the receiving party, prior to the execution of the document. Okay. In fact, you often see that situation where, people realize, oh, gee, now I need an NDA. And so that last line about, things received prior to is often an important one given the fluidity of discussions and negotiations. So a narrow definition, right, supports the receiving party, right? Because now as I discussed, if I'm labeling it confidential or proprietary, that's the only thing that the receiving party has to, be concerned about. And then if we're saying another way to make that limitation is to have it actually disclosed. So not something that I, gathered myself, not something that I figured out, something that was actually disclosed. And then of course, limiting it to as of now. So you get a lot more clarity in this situation for the receiving party. And since, you've got the burden of protecting that information, what you want is as much clarity as you can get. So obviously somewhere in the middle is usually the right place to be. So we want to have as much protection as the disclosing party needs, but not so much that it becomes onerous for the receiving party. So as I said earlier, often a mutual NDA makes people comfortable, because if I'm both the receiving and the disclosing party in both instances, then, I'm thinking about, that protection versus burden situation. Another way to do it, to find a nice middle ground, is to call out certain things. So my sales lists, my employee separation procedures, my et cetera, and then anything else that a reasonable person under the circumstances would consider confidential. So I get, this catch-all at the end, but I have, some clarity, and then we have some understanding of where a reasonable person might be thinking. So is just as important to define what's not protected, and to be absolutely clear about it. The law won't. There are certain things that the law won't let you, sweep in no matter what you say, but you want to be clear about what's not in, because you might be able to rely on the law later. But really, the most important thing that you're trying to do with any contract document is define the relationship and define the mutual understanding of the parties. So the more clarity you can get, the more that you can surface these things in the document, the better. So things that are available to the general public through no fault of the receiving party. So I didn't steal this information from you. I didn't do anything wrong, but I have obtained this information in some other way. So because the nature of things that we keep private are things that we want privacy protection on, and confidential protection on, the nature of those things are that we're keeping them private. The argument from the receiving party's perspective is, this wasn't private. This information was out there. So I don't have an obligation to you around information that kind of everybody knows or that other people know. So that's it's very similar, available to the general public as the sort of general one, and then, obtained by the receiving party on a non-confidential basis by someone who didn't have a confidentiality agreement. So, your employee told me this, they're not bound by confidential information, by obligation of confidentiality to you. And so now I know it. If I already possess it prior to the time we did the NDA, unless we've got that retroactive, benefit, then, I already knew it. So you can't stop me from knowing it, and you can't stop me from using it. Anything I've independently developed, you always want to be very clear about that, without use of your confidential information. So it might look like your confidential information, but if I didn't use your material to get it, then I won't, be bound to you. And then common knowledge in the industry, things that we just know, you can't decide that you own and that are confidential to you. And then we'll talk more about information that's subject to a subpoena, but, in those cases, in such a case, there are disclosure obligations around that. So how do we determine, what use? So you want to think about, how will the receiving party be required or permitted to use the information? If they're, and then with whom can they share it? And then how will they, what burdens will we put on them? So, thinking about the purpose of the use, the purpose should be specific. It should be narrow enough to prevent overuse, but broad enough to prevent them from using it in other ways. So if we're contemplating a transaction and you are going through my financials, I've got to give you the right to do that, and to get as much to use it in all the different ways that you might need to use it, but not in a way where you are permitted now to compete with me, for example, using the information that you learned. The risk is, a big consideration, if you define it too narrowly, we'll need to amend a new NDA. So a common way to do it, if you're contemplating a transaction, is to have an NDA that'll do both, right? So it's to as we're considering whether we want to engage with one another, and then once we engage, the NDA will still work in that situation. Who can make use of the information? So you want to make sure that the disclosing party, especially if they're a large firm, a company, that they closely hold the information. So a good way to do that is to say, okay, they can share your information with employees who have a need to know, or put some special restrictions on it. So these types of employees, these, you can be very specific if you want to do that. You want to be careful that you don't, we often think about, like, okay, so their employees, their employees need to know in order to do the work that they're doing within the firm, but we often forget, they may need outside advisors. And so employees is often not broad enough, especially if I'm contemplating a transaction. I want my lawyers to review this information. I want my financial advisor to review this information. I want to make sure that we have language in there that's broad enough so that you're not burdening the receiving party, or that the receiving party doesn't inadvertently find themselves in violation of the agreement. And then, some ways to think about this need to know, that you may include that they have to be informed of its confidential information, and that they need to know it because, and then however you describe your purpose. And the most important consideration here would be that the receiving party, the entity, is going to be legally responsible for any breaches by any of the individuals. So one thing you can do in that third bullet there is that you can ask the employer or the entity with its advisors, et cetera, to require the employees or the advisors to sign an NDA that will require them to protect the information on at least the same, with at least the same level of protection as you are offering to the disclosing party. It's up to, it depends how onerous we want to be in these kinds of things. If you have the the receiving party be legally responsible for any breaches, again, you don't need them to have their employees or advisors sign those documents, but it's always good, because again, it sets forth the expectations that people have, so there's fewer mistakes later. With so much of NDAs, the most important thing is that the information just not get out. Yeah, there'll be remedies that we'll talk about at the end, but in many cases, it's hard to put that genie back in the bottle. So how do we, so, how do we ask them to safeguard the information? We can use a couple of different standards, and actually the one that works best is a combination of them. So we can say we want our disclosing party and any of the people that work with them to use at least commercially reasonable a degree of care, right? So whatever is, in the industry determined to be a reasonable thing for people in this business. We can also say no less than that used to protect their own information. This is always a clever thing to say, because now what we're saying is, how, you have to be as careful as you are with your own stuff, and assuming you've got a partner who you think's responsible. And I would argue you shouldn't be disclosing any information to someone who you think's not responsible, even if you have a legal document to to quote unquote protect you. So if you're working with someone who is responsible with their own confidential information, you're asking them to apply the same standards to yours. So people are often happy with that kind of level, and they often, it often feels not that burdensome because they're already willing to do it for their own. And it feels kind of fair in that, like, in the way fair feels, the way fair felt when we were little kids, like just, it feels right. So you want to provide the return or destruction of confidential information to, protect what's out there in the world after you are done. Nowadays it's mostly destruction because we're doing a lot of this electronically. So, we don't really need it back. There'll be another digital copy as we keep sending things, back and forth. What we actually want is for you to destroy it and to certify, that you've done so with some written confirmation. It's also, costs might be an issue if you're requiring physical, the physical return of things. So you can have two provisions, that when the relationship's over, or when the termination of the NDA relationship or the larger relationship, you choose between those two, or you can say, upon request, anything's got to come back to me. Now, if some people worry about, the receiving party's demand of their confidential information back, midway through our, what we thought was going to be the length of our relationship, there can very well be other damages that you can seek from them if it makes it impossible for you to do the work that you contemplated. But nevertheless, the information, the important thing is that the information goes back. So I might demand, there might be a reason why I demand my information back, and then we figure out what the consequences are to the other party later. But my the protection of my confidential information, comes first and foremost in that situation. So we're going to have limitations on, on the protection of this information. So, how long do we want to protect it? How long, how long do we have to safeguard this? And what do we do if we're compelled, by subpoena or otherwise? So you can, there are lots of different ways you can determine, how long the confidential information is going to be kept. You can have a specific term, it's 3 years, it's this long. You can have that continue past the termination or expiration of the NDA. So the NDA is expired because I'm no longer giving you more information, but I'm going to give, but you've got 3 years, 5 years, 2 months, with which to, use the information before it needs to be returned or destroyed. If you don't say anything, then you've got, perpetual confidentiality obligations, which again might sound good to the, certainly sound good to the discloser, but to the recipient of the information, they've got to safeguard this information that's not theirs, and then be subject, be vulnerable to lawsuit. So often there's some sort of tail, we call it, that extended term, some period of time after the NDA has expired. So you can do this with individual pieces of information. So you can have a 3 year, so 3 years from every time that there's a disclosure. It's if 3 years is the right amount of time before you think your information goes stale, and that's how long, or maybe I'll say it the other way. If 3 years is the amount of time where your information is, vital and important to you, then, you might want this, kind of constant 3 years. But the downside of that is that if I'm receiving that information, I've got to know that I got information A in September of 2023, but I got information B in January of 2024, and they're all different terms. So easier, cleaner to do a protection, one protection, get us through the entire term of the NDA, while I'll be disclosing potentially at any, at different points along the way, and then say X years at the end of that. You want to be clear that there is some information that's protected in perpetuity, and that's trade secrets. So let me jump in on trade secrets, right? So trade secrets is any information, including things up on the screen, a formula, a pattern, a compilation, a technique, a process, etc., that you derive economic value from not being known, but in order to keep it a trade secret, in order for it to be a trade secret, a legal trade secret under the law, the party who owns that trade secret needs to take reasonable efforts to maintain its secrecy, right? So this is the Coke example, right? The formula for Coke is a trade secret. It is, something that it is a formula that the company derives economic value from being, held close, and it is a subject of reasonable efforts. It's actually the subject of very unreasonable efforts to keep private. Coke's got some really funny, things they do, but because it's that important to them. So they are and why it's so important is trade secrets are only protected as long as they're covered by trade secret protection, meaning your information stops being a trade secret once it becomes generally known, once it gets out there. So as the discloser of any trade secret information, you want to make sure that you've got very strong protections, and that you are, being very limited in who you, share those secrets with. That said, those things will outlast the term of an NDA. So this thing about protecting versus safeguarding, right? I've talked a little bit about already, right? The key is you want to balance the benefit of protection against the burden of the safeguarding. And so, it is kind of one party's, benefit is the other party's obligation. And so you want to make sure that you are, that when you're figuring that out, you're getting just enough, but not so much, as to make it unattractive, right? I don't want to hear your secrets if I have to keep them secret for, tens of years, in lots of complex ways, right? I'd rather not even contemplate doing a transaction with you in that circumstance. There are some circumstances where you're required to disclose, a subpoena or some other order of the court or an order of Congress, right? We've been seeing those kinds of things recently. So they may be permitted whether you say there's no disclosure or not. So what you're doing what you're taking the opportunity to do in the NDA is to say, okay, if you need to disclose, do these things for me, right? Notify me of the disclosure, and then take all the steps you need to treat that information confidential when you comply with the order. So mark it as confidential, or submit it to the court in ways that the court will be required to keep secret and won't be part of a public record. So you can spell that out, and there's pretty standard language for doing that. And so the sort of whole reason we're doing this is because we want to define our consequences. We want to allocate liability. What happens if things go wrong, right? The information that we've got is valuable to us. We own it, or we need to keep it confidential. There are serious consequences if that information does get disclosed. And so the way we attempt to ensure that the information doesn't get disclosed is we have consequences for what happens if anything goes wrong. And as I say, it's the best case scenario is that you're disclosing to a reputable party who is going to keep those consequences in mind and then not disclose, because that's the most important thing that you're looking for. So one of the key things to have is equitable or injunctive relief. So, there are circumstances where money might not even compensate for the fact that your information is made public. So what you want is the ability to enjoin the party from using the information or distributing the information, and then to offer that kind of protection. And then in addition, there are damages for the loss of profit, for the loss of opportunity, that you can have calculated. But one of the most important things is to have this injunctive relief in there. And the theory is that, money can't compensate me fully. I need to stop the breach. I need to stop the information from being, take the information out of your possession. I don't know why this got so tiny, but they are the sort of other things not as important as these top 5 things that we've been talking about. You want to be clear that the sharing of information doesn't transfer ownership of the information, right? Whoever disclosed it still owns it. You want to be clear when you disclose your information that if the other party relies on that information, and there was something inaccurate about it, that you are not responsible for that. And obviously you'll be limited in whether, if a party is evaluating your financials and you give inaccurate financials, you're not going to be able to insulate yourself that way. But for certain circumstances, it's my information, I'm going to share it with you, and then, take from that what you will. And the last is that there's no obligation to enter into a transaction. So I'm sharing this information with you while we contemplate that we're going to do business together, but that doesn't mean that we will absolutely do business together. Look at that, perfectly on time with 15 minutes for questions. So thank you. I appreciate your attention. I find this stuff interesting, and I hope you do too. And I'm happy to answer questions. I'm going to stop sharing.
Thank you for all of that information. So good. We have a lot of questions for you lined up. So we'll get going here.
Talking, yeah.
Jenny, if I could jump in before you just do it. First off, as always, Jessica, thank you. A lot of great information and so valuable. I think the thing that really jumps out at me, I think, is so much about the kinds of small business owners we work with. And maybe many of you on the call today are, maybe you're acting informally, or maybe you're a sole proprietor where you're trying to kind of figure out how all this builds in, to your operation. Maybe you're operating a small business and you're thinking about kind of hiring contractors. So whichever side of a transaction you're on, I think, being able to have a sense of, what you need to keep close to your vest, what you need to make sure that you're doing to kind of, control for any of these sorts of issues going forward, I think is so insightful and important operationally. So I was looking through the questions, and I think a lot of that kind of relates to that as well. So I just wanted to kind of throw that out, and thanks again. And if we can be of help, obviously we're so happy to try and do so. So thanks.
All right. So some questions regarding timing. At what point of the conversation in a business transaction is it appropriate to bring up the NDA?
I would say this is a business concern as much as a legal concern. Depends on what, I have some clients who won't, who are on either side of this, who will not disclose one single bit of information before there's an NDA, or who are now in a position where, they can't get any information from anyone else unless they've signed that NDA. It's about bargaining power. It's about how proprietary your information is. Where your conversation's going, and where, want to bring it up as early as possible, you know, like certainly before you've shared anything confidential, but, you know, after you've established some kind of relationship or rapport, right? But I think with NDAs lately, people are more and more understanding of the importance of, you know, keeping information confidential. You know, we're much more sophisticated about, you know, what we're doing and why we're doing it, you know, and because we're, you know, you're often in a, you know, you know, what you're trading on is knowledge and information, you know, it's not the kind of thing that will put people off necessarily. And certainly if you put a mutual NDA in front of someone and say, you know, I want to protect my information, I want to protect your information, you know, how about we sign this before we go any further? I think is often, you know, not unwelcome and often quite welcome.
Okay, so when shopping around for a contractor, would you say that it is then typical to ask for an NDA for like a free consulting session before the actual hiring? Or is it more typical once you're looking at the official working partnership?
I don't know. Yeah, opening up a little. I'm not sure if that's my connection reach, but so when you're contemplating, sorry, can you repeat the question? Because
So is it typical to ask
everybody's
for an
phrasing
NDA
this.
to be signed during a free consulting session before hiring, or once you are entering into the official working partnership?
So I don't think there's typical or atypical in this situation. It's, you know, if you're having a general conversation where you're getting a feel, you know, you wouldn't need an NDA. If you are, and I think maybe it depends, I can't tell what side of the transaction the NDA person might be on in that circumstance, you know, so if I'm offering you free services, you know, I might be less inclined to want to sign, you know, something before I also give you my free services. But if you are the party who's offering the free consultation or the free services, you know, you'd certainly, you know, again, it's about bargaining position. You know, you might be more likely to say like, great, here are the forms that I use, you know, before I do my free consultation. But, you know, you can always just, you know, manage what what you disclose. Lots of people offer a free consultation on general, you know, matters, and then don't, you know, reveal their secret sauce or their Coke formula, you know, before, you know, until they, you know, start a relationship.
So is making an NDA with every contract usual for some businesses?
It can be, yes, if that's, you know, if absolutely, you know, if your information needs to be kept private, kept confidential, you know, doesn't matter the number of people that you're going to work with, you're going to want NDAs with all of them.
Okay.
I would just sort of say operationally also, I mean, I think in terms of some of the folks that we work with, I think looking at if you're the provider, you know, your free session may be a way to kind of whet the appetite of a prospective client. So you want to be able to demonstrate what you're bringing to the table. So if you're signing an NDA, you know, that may lengthen the negotiation process in terms of getting somebody to say, gee, I want to talk to them. Where it becomes, as you know, if it becomes general, but it becomes, here's the special sauce, as Jessica was sort of saying about like, how do you engage me or my firm kind of longer term in a paid capacity, you know, that can be kind of a way to kind of get them along that path.
Right. So to clarify, if let's say someone meets with a business for a potential contract, signs an NDA as part of that meeting, they are still obligated to abide by the NDA even if they are not hired, correct?
Yes, if you write it that way.
Okay.
You know, that's this whole thing, you know, the NDA goes away, but you know, the provisions stand.
Right. Okay. So if someone in a company is about to disclose information to another company employee, is it okay if only the CEO has been the signer of, I guess, that NDA contract relationship?
As long as I talked a little bit about this, as long as the, you know, document binds the company, right? And the CEO is signing on behalf of the
Yeah.
company,
Mhm.
right? And that person's a company employee, then it ought to, it ought to be covering that person as well.
Right. So does the NDA approach, would you use the same NDA approach for contractors completing one-off projects as you would for, somebody that you were hiring for a longer term?
Yeah, I mean, you do it in a different document, but if you're hiring someone and, they're 1099 contractor situation, you put an NDA in front of them. And I think I would try, if I could, to just make the term of that NDA, potentially longer than any smaller engagement that they might have with you. So you're going to hire them for 3 months, but you're going to say any information disclosed, and then have the NDA go for 3 years. You may stop disclosing after 3 months, and that's fine. But if you, think it might be a situation where you're going to continue to work with them, you can do that. You can also have an NDA with no expiration. And you can, say that, whenever information is disclosed between the two of you. So you can kind of keep that sort of evergreen in that circumstance. And with employees, it should be, during the term of their employment, and then the confidentiality obligations might continue after, but anything disclosed or learned during the term of the relationship.
So on the point of disclosure, are there any clarifications as to whether it's in writing or verbal communication? Typically in NDAs, does that matter? Or is just disclosure always disclosure in any form?
So it matters because you're going to write the provision that describes what your confidential information is. So you're going to want to think about how information is going to move from one party to the other. And you can, it can be physical, paper, it can be electronic, it can be oral, you can say, anything, that they learn. So you want to craft it to, how that, or you might not want to limit it, you just want to talk about the information, as I said, however obtained, in whatever form or format like that, so that you cover those types of things. If you are the recipient, you're gonna, you might want to, and you're worried about who knows what's going to be said and how, then you'll want to limit it to disclose to written, received, maybe marked, if you can do that, right? You want more clarity there.
Okay. Thank you. If someone breaks an agreement, what are the steps to take at that point?
So the benefit of any contract is that it's a purely private relationship that then you get to bring the full force of our government down on them if you need to. So you're gonna bring them to court. You're gonna seek an injunction first and foremost, because that's, you need to stop the damage. And then you're going to seek damages for the harm that's been caused. With so many things, you might start with, a conversation with the other side, hey, do you know this is going on? Let's make it stop, et cetera. And let's, make me whole, same for any contract situation, really.
So just a further clarification on that. What are your thoughts as far as arbitration versus filing a complaint in a scenario where something has happened?
Arbitrators don't have the ability to enjoin anything. You need the courts to do that. So you're gonna want to go to court.
Okay. Let's see. There's a question. How about common law and filing a claim against the person instead?
I am not sure I understand.
Maybe that person can give us some further clarification on that question. So if someone, this person's given a scenario, if a trade secret has been disclosed under NDA, and then this person well, this information ends up anonymously on the internet. And now the claim is that it's public info because it's on the internet. What protections can you do to put in place to protect against a scenario like that?
So protect against having it get on the internet, or protect against, what's going to happen next. With all these things, proof is always the most important, it's always the thing that we don't know about, lots of people, so you want to link that disclosure. You want to link that anonymous disclosure to the party who had the information. That's one of the things that you'll be doing. I think the end of what was the end of the question that was actually asking me?
How can you protect against this?
Yeah. So, so if I think I want to hear it again. So if I think about protecting, I can protect against my information getting out by never giving it to anyone. I'll make successive, less protective things by, disclosing under an NDA to a reliable, partner. Once it's out, I think it sounds like, once it's out, it's out. And so then it's just a matter of, how to rack those damages up, what those damages rack up to be so that you can sue. I guess now's the time to talk about being judgment proof. You want to, when I say reliable partner, you also want to be, disclosing to someone who maybe has the means if they violate the agreement. Right. When I was in law school and I had, 25 cents to my name, I was like, yeah, I'm like it's called judgment proof. Like, you come after me for whatever you want, I've got nothing. There's nothing that you'll be able to get from me. So, it seemed funny at the time. But it's not funny if you are working with a judgment proof, defendant, someone against whom, won't matter, right? If they cause you millions of dollars worth of damages and they've got an old used car and, a couple of law textbooks, it's not gonna, it's not gonna help you any. So with many of these things, it's the preparation. The NDA is one of the pieces that you're going to be doing to try and protect your information from being made public, because once that's made public, the consequences, may be irreparable.
Okay. So we got some clarification on the previous question about common law. So this person was referring to filing a claim instead of a complaint, not against the person, but against the man or woman who harmed them, the wrongdoer. Is that a good way to seek reparations? I
am not sure I understand the difference between claim and complaint in this circumstance. If the distinction is, I've got an NDA with with an organization, and then one individual has, violated that NDA, am I going against the individual? Sounds like that's maybe what they might mean. You're often, you want to go against the person who has the most money, the deepest pocket. So, the person who's in the, the person entity, who's in the best position, to make you whole, if that's the case. Potentially you're not able to, so that's one thing. And that's often the, the signatory to the agreement, not the underling, right? If I give you bad advice, you want to sue Pace. You don't want to sue me, my employer. So, but in some cases you wouldn't even be permitted to sue that person individually. So it's gonna depend on the circumstances. But I think a business decision is going to be what drives that.
Right. So we are at 1 o'clock. We do have a few questions left, and I want to be respectful of your time. So would you like to handle these questions after the webinar?
I have a couple minutes, so if we
have a couple minutes, okay. Let's see what we can get through then.
Quickly.
Do the New York rules about power disparity affect NDA contracts with potential employees?
No, they're I believe right now limited to people who are trying to use them in ways, where something's already happened and they're trying to use them in ways to silence the party from speaking up on that.
Okay. So would you say that NDAs are an effective way to limit independent contractors that may become competitors after working with you?
They are more effective than not having NDAs, but non-legal considerations are always going to be the case, right? How do you prove that they're using your confidential information after the fact if they have, so they're more effective than not having it because you've set expectations, because now you have a chance to sue. You wouldn't if you didn't have that, but you're still going to have the practical considerations of someone who's going to claim that they've built that information, they've learned that information independently, or something like that. So there's always going to be that risk. What you probably want to do in that circumstance is, combine that NDA with some kind of non-competition agreement. Non-competition, there's some really interesting things happening in New York that are, changing the laws around that. But something that says, they can't work for a similar company for some number of time, some amount of time, right? And so if you carefully, there are rules for how you craft that. That's actually a whole other webinar that we could do, and we've actually talked about it. But if you craft it appropriately and it holds up under the law, what you have to be thinking about is like, when would my information go stale, right? That's how long I would need to protect it then with that non-competition agreement.
So is there an NDA agreement for accounting firms? And what happens if the team is remote? Like, what is the jurisdiction for that?
I don't know that there's some general NDA for accounting firms, right? People, can put whatever obligations they want, as long as someone's willing to sign up for them. And then remote. You should be the agreement, the law that governs the agreement might differ based on the law. That's I think I talk about that maybe in the webinar next week. How you figure out where the agreement is taking place so that where you can sue and what law will apply. But there's no reason to suggest that someone isn't bound by an NDA because they are outside the jurisdiction, right? If you share your information with me in New York and I take it to California and then breach my obligations, the place I'm doing it doesn't matter. I'm still under that obligation. So remote work shouldn't matter.
Thank you. This question poses a situation. So it takes the scenario of software code or a product being developed. And even if you request for the confidential information to be given back or destroyed, what safeguards can be in place to prevent the receiving team from recreating the idea of the software as a similar product? Like, even if they don't do the work themselves, what safeguards can be put in place for something like that?
Yeah, that's a whole other webinar. And I think you run an intellectual property. I mean, that's more of an intellectual property question. What information is, so let me answer the most narrow question. What safeguards can you put into place to, stop someone from having learned your information and then not using it, but using the ideas, but, like in your NDA, like none, so, reputable people you're doing business with, et cetera. But if you have protectable intellectual property, and then someone else, there are limits, so I think what the question actually said was, if they take the idea of it, ideas are not protected. But if that's literally the thing, then there'd be no Oh, good. I see, Andrew, you put it in the in the chat. So, the idea of something is not protected, but the creation, that the intellectual property that I created may be protected. But if you built yours off of what you took of mine, there's some, you would be, the other party would be limited, would be prevented in, lots of cases from doing that. But it's going to be like, was it the idea? Was it was it built off of the other thing? So it's going to be an intellectual property, matter. And that'd be a great webinar to go to.
Got it. Do companies ever offer any kind of training on NDAs that a receiving party can go through to make the situation clear?
Tricky. I mean, so legal training, like unlikely that I'm going to train, I'm not going to give legal advice to someone who's supposed, in opposition to me. I mean, I certainly could, but they shouldn't take it. They should seek their own, legal advice, because there's a conflict there. Do they, I mean, you ought to train, not just in NDAs, but in, safeguarding information, and your information as well. I mean, one of the things that you might see sometimes is, like a little email signature that says like, nothing in this, is an offer of sale, or, something like that. And you're doing, so think about that. People are doing that because they're sort of worried about what their employees might be getting up to, like what they might be saying in emails, right? So that's not NDA related. But the more training you can do for your employees about, what to sign, what not to sign, like how to behave around other people's information, right? You absolutely ought to do that if you're taking in other people's information and they are, and you're going to be bound by what your employee does. You absolutely need to do that. And, will not need to do that, ought to do that so that you can protect yourself. And then, certainly, because of, like I said about those email signatures, you want to make sure that you're training people in what they ought not to say so that they don't inadvertently disclose things, to people who don't have an obligation of confidentiality back to you.
Right. All right. We still have more questions, but do you need to go? You have provoked a storm of questions that people want answered today. So thank you.
Let's take one more and let's end it there.
Okay. So this one has to do with destruction of information. Is it okay to keep a record of participants or users of someone's service for their own records, to remember them in case they are called to, like, let's say, serve in some sort of litigation? So yeah, the data destruction, could you speak to that a little bit involved with the NDA process?
I mean, it shouldn't matter destruction or return. And I don't know, depends what you've, depends how it's been written. Whether it depends what you're obligated to destroy or return, and what's considered confidential information under that, right? So you said record of the participants in my services, like, I don't know, is that part of the, is that part of what was considered the, the confidential information that, that was disclosed or that was developed, right? So that's where the definition of proprietary or confidential information is going to be the most, important.
Understood.
Yeah.
Well, thank you so much. For everyone that we didn't have time to get to your questions today, remember that you will get a follow-up email tomorrow, and you can respond to that with, that'll come to Pace, who can get you some information and connect you to Jessica. You will also have a link to the recording in that follow-up email, so you can look for the part where Jessica shared her contact information at the end of her presentation. And let me see, I'm just looking through our chat really quick here to make sure I'm not missing anything.
Jenny, while you're going through that, I just wanted to sort of thank Jessica, who is an engaging and terrific presentation. So thank you so much. And Jenny, thank you as always for helping us sponsor and promote and kind of make sure all logistics go great. A couple of quick things I'll mention kind of in closing. I guess number one, just as a reminder, our center provides no cost one-on-one business advisory services, while we can kind of offer support kind of in operational issues, financial, marketing, and otherwise to kind of support some of the decisions and discussions we had today in terms of, you know, how you go about operating your business. We do not provide direct legal advice ourselves. So I just want to make sure that was clear. We do work with a wide range of nonprofit providers here in New York City, the New York City Bar Association among them. So if you're interested in figuring out how to kind of connect with them, your good first step would be to sort of connect with one of our business advisors to kind of go through what you're looking to do and how that might be able to be helpful. And the final note, I guess I would mention again, a pitch for next week's session. Jessica's coming back to do a session on contracts and risk management. So I did put the link in the chat for the list for that session, a session we have coming up early in November with the New York City Bar on intellectual property and some other sessions that might be helpful to you. So I'd be happy to have you all join for upcoming sessions. And again, Jessica, Jenny, thanks so much for today.
Of
Yeah,
course.
thanks for having me. For hosting.
Yes, we will sign off. And if you have a moment to do the webinar survey afterward, we would love to get your feedback on this session. Thank you again, everyone, and have a lovely rest of your day.